you recall him saying, and by him I mean Mr. Peters saying, yeah, dude, I killed somebody who wasn't attacking me, and I killed somebody who wasn't advancing on me.
Witnesses are here, and I'm going to have them testify.
Thank you. You may call your next witness.
We would call Don Grieve.
Yeah, just at this table, but I'm not certain that that wheelchair will fit by that table of Mr. Stermitz's. You might have to, yeah, Mr. Stermitz, you might have to pull that back. It doesn't go through there?
No, it's not going to go through there.
You know, unfortunately, that.
No, I can walk, I just can't walk long.
Oh, okay, okay. If you can, why don't we come take a seat?
Give her a hand.
And, yeah, just if you could make your way to that first table, that'd be perfect.
Thank you.
Thank you.
I haven't had to go
Thank
the
you.
last 4 days.
Okay.
Hi, son.
Okay. Are you settled there?
Yes.
Do you want that on the chair next to you?
Yeah.
There you go.
Thank you.
Okay.
Hard moving all the time.
Very good. And I'm not going to make you stand up, but will you please raise your right hand? The other right hand. There you go. And the clerk will administer the oath. Please listen carefully and respond appropriately.
You do solemnly swear or affirm that the evidence you're about to give in the matter now pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God, or the pains and penalties of perjury. Thank you.
Thank you. Mr. Stermitz, you may proceed.
Don, can you state your full name?
Don Grieve.
And it's Grieve,
Grieve.
2 syllables. And you're August Peters' mother, correct?
Yes, I am.
After August got out of high school, did he reside with you here in Winnemucca?
Me? Was you in Elko or with me?
After high school, did he live with you here in Winnemucca?
Yeah.
And what was that here, just across from the courthouse?
Yes.
Okay. And was August working at Walmart at that time?
Yes, it was.
And did Brian Christie live in your house with him?
Yeah, I did.
Okay. You have an apartment, correct?
Yes.
Okay. And can you describe an incident that occurred one day when August came home from work and had an encounter with Gerardo Alcaraz?
Yes. My son had just got home and he's like irritated, you know, because he just got off work and he walks from my house to Walmart every day. And I think he was even working a double shift. He was really tired. I'm not sure, but it's my,
Sure.
you know, thinking. He came on in the house and Brian went up to him and said, "Come here, August." And they went in the room and all of a sudden August got all, upset. Well, he was upset because he had told Geraldo, "Don't just walk into my mom's house. You knock." And see, Geraldo, this is what Brian Christie said, that he just walked in the house. You know, and I was asleep, and I got a bed in the living room. I always wake up. I'm, easy to wake up, and I can wake up. I can see Geraldo, just walking the house. So I'm thinking, oh gosh, Brian's starting, to ruffle August's feathers, But anyway, August went outside to tell Geraldo, you don't come in my house without knocking, period. And Geraldo, I guess, hit him and they started fighting. Well, August had his hair, he had a hold of August's hair like this, and his hair was long and tight, like this, and kept going like this. And we had like metal poles in the inside of the apartment and kept hitting him, like hitting his head on there, back and forth, going the other one. Then he went to the cement walls, what we got, and started doing that. Well, before that even happened, he punched August in the mouth, and August lost his tooth because of Geraldo.
And did this happen you know what year this happened?
About a few years.
Okay. And was it shortly after this that he relocated to,
Oh, the very next day, he moved.
moved to where?
I just.
To the RV park?
Yeah, he just wanted to get away from that guy. He didn't want that guy over it anyway, you know.
So my question is, this happened relatively shortly before this incident that we're here about today, correct?
Oh, I said again.
Well, this happened just a few months before Doug Higginbotham was shot, is that correct?
Oh, yeah. It was like right after.
Okay. And did Mr. Christie at that time come out to help August?
Oh, yeah, he came out with a gun, like a cowboy gun, long cowboy gun, I think it was. And he aimed it at Geraldo's sister, and Alexis is her name. And she just ran up and said, shoot me, I don't care, shoot me. And he ran back in the house and shut the door and locked it.
Did Mr. Christie do anything to assist August?
No, not at all.
He just let him get beat up?
Oh, yeah. The only thing he did was bring out the cowboy gun and act like he was shooting.
Okay. Did you write a letter here on behalf of your son?
Yes, I did.
Okay. And I'm going to show Ms. Grieve what's marked as Exhibit A. And could you read that?
Hope so. Dear Your Honor, my name is Dawn Grieve, and I'm August Peter's mother. I want to express to you about my son. So here it goes. My son is a sweet, sensitive, loving man. Since I became disabled, he has taken care of me. I can't read that one more, but he's something me. I can't read it. I'm sorry. I'll just read what I can. I guess he cheers me up when I'm down, that's what it says. Treats me to pizza. To pizza on his paydays. He puts a lot of thought into my Christmas and birthday presents. He really knows his mama. I want you to know, August is truly a hard worker. Many times after working a full shift, he walks home and then he gets called in to work another shift. He turns around and goes back to work without a complaint. And this happened many, many times. August, many times, is a true friend and asked me many times if a friend could stay with us to get his friend. He truly cares for people, and he has the highest respect for people, no matter what race. I'm so proud of August, and from the bottom of my heart, know he's telling the truth. When he told me the man he shot and killed was because the guy threatened to kill him. Sorry. In August's own word, expect to kill him in his own yard. And at this end of, and the end of the day, and then he says, at the end of the day, he took a man's life. That's what he was telling me. He has told me many times, at the end of the day, the man's daughter doesn't have a dad anymore. And his wife doesn't have a husband. August has so much remorse, even with it being self-defense. His remorse is almost unbearable for him. Your Honor, August has been locked up for a year and a half, and I'm asking you to please have mercy on him. When you make your decision, I ask you, please give him credit for the time he served and probation. I need him home to help me. I have heart failure. I just got a compound fracture and metal instead of a bone is in my leg. I'm on oxygen for 24 hours, 7 days a week. He is needed home, sir. Thank you so much for taking the time to read this. Yours truly, Don Reed. I tried.
Good, thank you, Don. We passed the witness.
Mr. Pasquale?
I don't have any questions.
Okay. Hearing no questions, ma'am, thank you. You may step down.
And you would move that A admitted.
It's also been filed.
No.
Sentencing exhibit, but
I don't know, Your Honor.
no objection, exhibit A is admitted.
Uh, Mr. Peters would call Sergeant Patchen.
Sergeant Patchen. Good morning, sir. How are you?
Pretty good.
You'll face the clerk will administer the oath. Raise your right hand.
You do solemnly swear or affirm that the evidence you're about to give in the matter now pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God, and the pains and penalties of perjury.
I do.
Thank you. Please come take the witness stand. And unless you're under some quarantine for COVID, you may remove your mask. Thank you.
Sergeant Patchen, can you state your full name for the record?
Joseph Allen Patchen.
And how are you employed?
I'm a sergeant at the detention center.
And how long have you been employed in that capacity?
I've been a sergeant for 3 years.
And you know August, or come to know August Peters, who's seated next to me?
Yes.
And do you recall what day he was initially booked and incarcerated in Humboldt County Detention Center on the current charges?
I wasn't on duty that day, but I know it was May 9th.
Okay. And did there come a time when August was made an inmate worker?
Yes, there was.
And you recall when that was?
It was, can I look at my notes?
Is there any document that would refresh your memory?
Yes,
And do you have that document?
I do.
Could you look at that? Does it refresh your memory?
Yes, it does.
And what day did he become an inmate worker?
July 9th,
And that was in 2021?
21.
And is he still an inmate worker?
Yes, he is.
And did you make the determination that he become an inmate worker?
I did.
And what sort of inmates do you vet? Or is there a process for vetting an inmate to determine whether they are going to be allowed to be a worker?
It has to do with the crime that they're accused of, and also the behavior that they're displaying within the jail.
Okay. And so what sort of people would you not want to have as inmate workers?
People that aren't following the rules and are assaultive or disrespectful to our staff or a danger to other inmates.
And apparently, the determination was made that August Peters could be an inmate worker. He was not a threat to or disruptive with other inmates, and he could follow rules. Is that fair?
Yes.
And does he get any kind of benefit for being an inmate worker?
At this time, no, because he's not sentenced, other than more freedom within the jail.
He gets to live in a different location.
Yes.
Then, and he also gets to. What do they do as an inmate worker?
Cook, clean, do laundry, wash vehicles.
Is that something that's sought after?
Yes.
And I assume it's because it keeps you busy and breaks up the monotony and.
Yes.
During the time that August has been there, do you know whether he's had any write-ups or incidents?
He has not.
We'll pass the witness.
Mr. Foley Cross?
Judge, I don't have any questions for the sergeant, thank you.
Thank you, you may step down.
And I would call John Roger Peters.
If you'll please stand before the clerk, raise your right hand, clerk will administer the oath.
You do solemnly swear or affirm that the evidence you're about to give in the matter of pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God, under the pains and penalties of perjury.
Yes, I do.
If you'll please come take a witness stand. Are you currently under any COVID type of quarantine? You may remove your mask.
Thank you, sir.
Mr. Stermitz, you may proceed.
John, could you state your full name?
My name is John Roger Peters.
And how old are you, sir?
I am 38 years old.
And you reside in Reno?
Correct.
And are you married?
Yes.
And who are you married to?
Rachel Arlie Peters?
And are you originally from Winnemucca?
No.
Is Rachel?
She did live here, but she's not from here.
Oh. And you are August's brother?
Correct.
And how are you currently employed?
I work as a commercial truck driver for J.B. Hunt.
And your wife, Rachel, how is she employed?
She works for the state of Nevada.
And recently you had an addition to your family?
Correct. We have a 1-year-old daughter.
And shortly before August actually resolved this case and pled to voluntary manslaughter, you traveled here to Winnemucca, correct?
Correct.
And you were able to visit with him?
Yes, very briefly, yes.
You were asked by me to draft a letter for purposes of sentencing today,
Correct.
and do you have that?
Yes, I do.
Could you slowly read that?
Yes. Okay. So dated January 21st, 2022, to whom it may concern, this letter is in support of August Anton Peters from his brother, myself, John Roger Peters, and his sister-in-law, Rachel Peters. August and myself share the same father. There is about a 14-year age difference between us. Due to August's mother's health and legal issues, August lived with his father and his brothers, myself and his brother Mark, from a very young age. Myself and August lived together until I graduated high school and moved out on my own. Periodically, I would hear about August and come and visit. August was always a very mellow, easygoing person, and like most kids, he was more interested in video games and friends than school. August went back and forth between his parents, so John Lloyd and Dawn. But we lived with, my wife and I, lived with August again in Las Vegas in the 2010 year range. He was having difficulties in public school, so he was enrolled in a virtual learning program. His father, John Lloyd, brothers, Mark and I, and sister-in-law, Rachel, all pitched in to help with his schooling. But he ended up moving back with his mother shortly after. As far as I know, he didn't finish high school, but found work in different fields. His attitude has always been laid back and go with the flow. He hadn't really shown any drive or ambition at that time. But since his incarceration, we've spoken with August a few times on the phone. The experience has seemed to change his mindset. He has expressed that in his He has expressed that his previous attitudes and behaviors are not what he wants to go back to, and he has indicated that he wants to find a trade or a career and make more of a life for himself. It is our hope that the court will see his youth and potential and will allow him to use this experience as a wake-up call to do better. We hope to see him use this as a motivation to stay out of trouble, earn a living, and grow up and be a happy, and grow up to be a happy as a young adult. Thank you for your consideration. Signed, John Roger Peters and Rachel Peters.
Thank you, Mr. Peters. We will pass the witness.
Mr. Pasquale?
I don't have any questions, thank you, Your Honor.
Thank you. You may step down. Thank you.
Thank you.
And our last witness is Mr. Peters, John August Spock. Thank you very much.
Good morning, sir. If you'll stand before the clerk, raise your right hand.
You do solemnly swear or affirm that the evidence you're about to give in the matter now pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God, or under the pains and penalties of perjury.
I do. Thank you, sir. If you please come take the witness stand.
And I have some underlying conditions, diabetes and hypertension and that, so I can put a witness on.
Okay, that's fine. Just make sure you speak up loud enough so that everybody can hear you, and if you use that mic, it will help.
Okay.
Okay?
Uh-huh.
Mr. Stermitz, you may proceed.
Mr. Peters, state your full name
John Lloyd Peters.
and where are you currently residing?
I reside in Beawawe, Nevada.
And August is your son?
Yes, sir. He's my youngest son.
You and how many children do you have?
I have 4 children.
And we met one of them today.
Yes, that's my oldest son, John Roger.
And who are the other 3?
Mark, and then I have a daughter, Latasha, who lives in West Valley, Utah with her mother. And then Mark lives in, I believe, Minden now. He's assistant manager at a Wendy's.
And you expressed a desire to make a statement at this proceeding, correct?
Yes, sir.
And what would you like to tell the court?
Well, first of all, I think my son is a good person. And I do believe that the situation that occurred is not likely to occur again. I don't really believe that he is any kind of a threat to society. And I think that if he's, given a second chance, that he will earn the trust of everyone involved. And there's also a couple things I'd like to clear up about what's happened. And because the trailer that he was staying in is my trailer. When he had his disagreement with his mother, I brought the trailer there to the Model T and parked it for him so he had a place to go. Now, he let Brian move in with him, and it's only a 25-foot trailer. It's not a really big one. So the reason that all this occurred outside is there's no room inside there. Brian had taken up the entire front of the trailer with a large double bed, and then there's a small hallway, maybe 2 or 3 people could stand there, and then there's a big bed in the back. So naturally, if someone comes up to the trailer, they're not going to come inside. Okay, you have to come outside to greet them. So this wasn't like he was, coming out there to challenge this person. He was coming out there just to see what was going on. Okay, it wasn't going to happen. It's not like, people seem to think that this was a situation where instead of the person coming into the house, that was never going to happen. There's no place for them to come inside. So, and my son has been taught also, you don't, we've always had firearms. We've been in Nevada for a long time. August was born in North Las Vegas. And the thing is that I'm sure, because of the training that he's had, that he was more concerned that this larger man that was proceeding towards him may take that gun away and shoot him. So he was definitely defending himself, the only way that he had available at the time. He wasn't gonna beat this bigger person up. He's not a martial arts expert or anything like that. So that's really all I have to say.
Thank you, Mr. Peters, who passed the witness.
Mr. Pasquale?
Very briefly, Your
You
Honor.
may.
Mr. Peters, what you know of this crime, you learned from August, correct?
Yes, sir.
And you frequently had telephone contact with him while he's been in the jail, correct?
I've either spoken to him on the phone or had video conferences more than 100 times with August.
And in one of those conversations, August actually admitted to you that this was not self-defense, isn't that correct?
No, it's not correct.
No more questions, Your Honor.
Mr. Stermitz, redirect.
Nothing on that, no.
Thank you. You may step down.
You know, in terms of evidentiary, we would rest, save and except that, of course, Mr. Peters would be allowed to make to allocate, I don't know if that's the end of defense, the state's case, or now. That's all we have left, this is allocation and argument.
And Mr. Pasquale, does the state have evidence for sentencing today?
I have one brief witness, 2 exhibits to present, Your Honor.
One brief witness, 2 exhibits. And then we'll have argument, allocution, victim impact statements, and sentencing. I think we're going to take a lunch recess. I would like, we also have some exhibits that have been admitted into evidence. I'd like a little time to review those too, and I don't want to take a significant break following the presentation of evidence and allocution to do that. So let's resume here at, let's resume at 1:30. Be about an hour and a half before lunch. Okay?
Thank you, Your Honor. Will we be able to?
Everything's going to be fine here. I'll make sure the curtain's locked. And we'll go off.
Thank you.
Recording stopped.
All right. You're excused. Yes, thank you for coming.
All right.
Thank you. You may be seated. It's not here.
Recording in progress.
Back on the record in case CR 207179, State of Nevada plaintiff, August Anton Peters, defendant. The record reflects the presence of the defendant with counsel Mr. Mathew Stermitz, Mr. Kevin Pasquale, Mr. Richard Haas on behalf of the state, Ms. Poole with Division of Parole and Probation. We'll continue with sentencing and the state. You may proceed with evidence.
Thank you, Your Honor. The state would call Detective Casalez.
Good afternoon, sir. If you'll please come stand before the clerk, raise your right hand, the clerk will administer the oath.
You do solemnly swear or affirm that the evidence you're about to give in the matter now pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God, or under pains and penalties of perjury.
I do.
You may come take a witness stand. And are you comfortable removing your mask?
Yes.
Currently under any COVID quarantine or?
Yes, sir.
Okay, you may remove. Mr. Pasquale?
Thank you, Your Honor. Detective, could you state your full name, please?
Jeffrey Casalez,
And how are you employed?
detective with the Winnemucca Police Department.
And were you a detective with the Winnemucca Police Department on May the 9th of 2020?
I was employed with the Winnemucca Police Department, still in a police officer capacity, but assigned to investigations.
Thank you. And as such, did you become aware of the August Peters case?
Yes.
And since that time, have you done any work on the August Peters case?
Yes.
Detective, showing you what's been marked as plaintiff's exhibit 1 for purposes of identification. Are you familiar with what that is?
Yes.
And what is it?
It's an inmate phone call from the Humboldt County Detention Center from the Securus phone system for inmate phone calls.
And it was reduced to a disc?
Correct.
And who did that?
I did.
Have you listened to the disc?
I have.
Is it an accurate rendition of the phone call?
Yes.
And, Your Honor, at this time I'd move for the admission of claims 1.
Exhibit 1, counsel?
We are going to make an objection. I don't know if I'm that concerned with the content, but what this is a phone call that August had where he's discussing with his father the plea deal that he apparently is going to take and some of the justification for that. The two problems is one, it really puts me, in a situation where I ultimately must become a witness because these conversations I'm having with August end up being the sort of things that he broadcasts to his father, and now the state's in possession of them. So I've got this attorney-client issue, as well as these are all about why August may be taking or not taking a deal. So I've never known negotiations to be admissible in either a civil or criminal proceeding. And I've got an issue with regard to attorney-client privilege. I think that I had filed a brief, and I think that was responded to, if I'm not mistaken. But I just would assert an attorney-client privilege, number one, and number two, that this is inadmissible negotiation matters.
Mr. Pasquale, would you wish to respond?
Oh, obviously, Your Honor. Mr. Peters' conversations with somebody other than his attorney are not privileged. There is no attorney-client privilege. And I certainly, this is not negotiations. I don't see me or Mr. Haas or anybody from my office participating in this. And this is a phone call between August Peters and his father. That's certainly not a negotiation at all.
I'm completely unaware of what we're talking about as far as this conversation between him and his father. You just have something on tape. There's an argument that it has something to do with negotiating his plea. Is that the subject of this conversation?
No, Judge, there's no negotiation of a plea as the
Well, I understand he's not negotiating a plea with his father, but is it discussing the plea negotiations?
No, Your Honor. It's him discussing the crime with his father and what he has decided to plead guilty to. And that is certainly not a part of any negotiation.
Conversation before or after we had a change of plea in the case?
I'm not sure the change of plea.
Sir, I don't know who's speaking back there, but you're not allowed to speak, okay? If you're on the witness stand, you can answer questions. If you're in the gallery, you remain quiet or you remain outside. Mr. Pasquale, I lost my train of thought there.
Thank you, Your Honor. This phone call took place on October the 22nd, 2021.
10/22.
3 days before the plea hearing.
Did we have a signed plea agreement on that day?
I'm not aware, Judge.
I'll take a look.
The plea agreement was signed on the 23rd of August, filed on October 25th.
One day before the signed plea agreement?
Plea agreement is signed on the 23rd by August Peters, and he's pleading guilty on the 23rd. For no contest.
Does the timing of this have any significance, Mr. Pasquale?
It doesn't, Your Honor.
Doesn't?
The two objections are that it's privileged, it certainly is not, and that it's part of negotiation, and it certainly is not.
Well, that's what I'm asking questions about. I'm not asking questions about the privilege. Not that this is an objection, but I'm interested, and this is my question. what's the relevance to this to sentencing?
It becomes really relevant, Your Honor, particularly after what we've heard this morning. We've heard all this talk about self-defense and the like, and in this conversation, Mr. Peters says this was not self-defense. I shot him, he was standing there like a dummy.
He didn't say this is not self-defense.
Well, he did.
Okay.
I never used the term self-defense.
Okay, hold on, counsel. You can talk to the court. Mr. Stermitz, do you wish to respond to the argument? I mean, I asked the question. I want you to get on to
He
it.
didn't say self-defense and he didn't say dummy. He's simply trying to convince his father, who didn't want him to plead anything, why he's pleading no contest. And so, I guess I feel it's negotiations are going on. I'm talking to August is talking to his father, and all of a sudden it falls into their hands. Is that just good police work? Is that invasion of attorney-client privilege? But the timing, certainly, this is what it's about. He's telling his father why he's going to accept these negotiations, or the reasons why, to a reluctant father.
There it is, Judge. He's telling his father why he accepted negotiations. That's not ongoing negotiations in any sense, by Mr. Stermitz.
Hold on, counsel. What's the intent if the court overrules this objection is this witness intending to testify as to what was said in that conversation, or do you actually have a recording that you intend to play?
I have a recording, Your Honor, and that's what's been marked as one, and what was offered as one.
Oh, okay. Is the recording of the phone?
It is, Your Honor.
Okay, the court's going to overrule the objection. I don't find that it invades the attorney-client privilege. I also am making this ruling on the grounds that it does appear to be relevant to some of the testimony that was taken earlier today, and the door which was opened by the defense calling as a witness the defendant's father, who took the witness stand and testified this morning. And I believe there was a question asked of him during that time about conversations with his son. So the court finds that the objection would be overruled. You may proceed.
Thank you, Your Honor.
So objection, that means Exhibit 1 is admitted.
Thank you, Your Honor. Detective, let me show you what's been marked as Plaintiff's Exhibit 2 for purposes of identification. What is that?
This is the report I generated based off the phone call.
Report generated by you?
By me, correct.
And what it is, what is reported by you? What are you doing in that report?
It's not the entire conversation, but a back and forth between August and somebody that I identified as John in the phone call as the conversation that they're having, and the times noted, certain comments were made.
Certain comments were made and the times were noted in your report.
Correct.
And were they noted verbatim?
To the best ability I could.
Okay, and so you transcribed portions of that tape?
Correct.
Your Honor, I move for the admission of plaintiff's to.
Mr. Stermitz?
Then we made our objection.
So this is a report that was as a result of the actual conversation, which has been admitted into evidence.
Correct, Your Honor, and this report excerpts portions of the entire phone call.
I'm going to sustain this objection. This witness is here on the witness stand. He can testify. He's subject to cross-examination. I don't know that the report is necessary. And the conversation itself has been admitted into evidence.
Okay. Judge, you know what, I think I've marked on that one, and that was the one I intended to use myself, and
Let's
I
just have
entered
the
the wrong
clerk.
one.
Yeah, let's just have the clerk mark. Then that is plaintiff's exhibit 2. You keep yours with your notes and have a clean copy for the record. It is marked?
Maybe I carried them both up at the same time.
Okay, so it is marked.
Thank you. Detective, in listening to that tape and in reviewing Exhibit 2, do you recall Mr. Peters saying, like, I'm at the point where it's like as much as I said it was self-defense, like deep down, dude, he was almost a yard away from me?
Yes, I recall that.
Do you recall Mr. Peters saying, he wasn't attacking me, he wasn't advancing, he wasn't. He was standing there. He was a dummy that stood still and I shot him. This is on me. I fucked up. I'm not going to sit here and fucking do this shit anymore, saying I'm in the right when deep down I'm not in the right fucking right.
Yes, I recall that.
Do you recall him saying, and by him I mean Mr. Peters saying, yeah, dude, I killed somebody who wasn't attacking me, and I killed somebody who wasn't advancing on me. He was standing still. He wasn't fucking attacking me. Wasn't nothing.
I recall that, yes.
And all of those comments were made by the defendant, Mr. Peters, to somebody identified as John.
Correct.
I don't have any more questions, John.
Mr. Stermitz, cross-examination.
What is the circumstances by how you came onto this audio tape of this conversation?
During a shift, not every day, I have access to listen to the secure phone call, as long as they're not private calls like, say, attorney-client phone calls. I can't listen to those, but any call with a family member or something like that.
So you do that day in, day out?
Not day in and day out, just sporadically if I get a chance to listen to calls.
Okay, so were you listening to this call live?
No,
Okay, and who brought it to your attention?
it's just one that I happened to click on Mr. Peters' phone call and I listened to the phone call.
And were you there at the direction of the district attorney?
No,
So I would assume this is not the only conversation you listened to between August and others on the phone?
no,
Now, you would agree with me, this was a discussion between him and his father about taking a plea to voluntary manslaughter.
yes,
And-
Well, objection, Your Honor. He wasn't identified as his father. He was identified as John in the previous testimony.
Understood, counsel. I understand that. Go ahead, Mr. Stermitz.
And do you recall him saying that he didn't want to take this?
I do recall him saying he didn't want to take that deal.
And who? Unclear to me, Your Honor, the question, who didn't want the deal taken?
Okay, I appreciate that. Mr. Stermitz, do you wish to clarify?
Did Mr. Peters say to you, I don't want to take this one, but me and Matt and got John involved, so they're going to be here tomorrow to sit and talk to me about everything? Do you recall him saying that?
I do.
And you recall him saying they want me to take 4 to 10. I plead no contest.
I recall that.
And you recall him telling his dad, so they gave me a deal.
I believe I recall that too.
And you recall him telling August stating to his father, I wouldn't really say it's them talking me into it, but it's like giving me advice, I guess. I don't know, man. I just told Matt, just get it knocked down to involuntarily and we'll take it.
I recall that, yes.
You recall his father saying that he can't be involuntary because there was a gun?
Yes.
Your Honor, I would renew my offer on stage 2. It's coming in piece by piece anyway.
Objection stands. Go ahead, Mr. Stermitz.
And do you recall John, the person identified as John, telling August that he thinks it's self-defense?
Yes.
And would it be accurate that it's thereafter that August Peters started telling his father, well, you know, I killed this person, and so on and so forth, everything he went through with Mr. Pasquale on rep?
Correct, yeah, I think after he said so.
So it's fair to say you've got August telling his father why it makes sense for him to take this deal.
Again, objection, it's not been established who August was talking to.
Sustained.
Well, who is he talking to?
When I typed the phone number into our system, it came up John Peters.
Okay. And you recall the person identified as his father, based on the phone number you looked at, that his father's advice is you have to do what you think is best, son.
Yes.
Again, Judge, that's still not been established.
What is wrong with the problem?
Hold on, both of you. I heard the question was reference to son. I'm going to accept that. Objection overruled. Mr. Stermitz, continue.
Do you recall?
I'm sorry, could you repeat that last question?
Let me go back. Do you recall the gentleman identified as John telling August you have to do what you think is best, son?
Yes.
Do you recall August saying, I think taking a deal and getting the F on with my life is the best thing to do?
Yes, sir. Well,
There's nothing further.
Redirect.
Nothing wrong, thank you.
Thank you. You may step down. I need the exhibits.
I have no more evidence.
Mr. Stermitz, are you prepared to proceed with our item?
One moment, Your Honor.
Okay.
I'm just wondering whether I need to call myself as a witness, which is somewhat difficult. Well, that's all right. I don't imagine I could do that. That's the problem with bringing something like this into the courtroom.
Your Honor, I object to those comments.
Mr. Stermitz, let's proceed with our argument.
Fair enough. Do not have allocution and anything else, or straight
Written
to
argument, allocution, victim impact statements,
Okay,
like I always do.
okay, fair enough, thank you. Been a longer day than usual,
It has.
or longer than since. You know, two things brought this on. And one, it was Brian Christie disrespecting Samantha Rain and Doug Higginbotham, common law husband, avenging, maybe honorably, Brian Christie's disrespect to Samantha Rain. Did methamphetamine play a part in this? It may very well have. Doug Higginbotham was under a acute level of methamphetamine intoxication at a level that experts say is sufficient to bring out aggression and anger, irritability, irrational behavior. August was 100% blameless in this incident. until he was faced with a choice. And that choice was whether he was going to take a beating from Doug Higginbotham or he was going to stand his ground. He had been struck by a man he didn't know. The man was angry. The man was bigger than him. Thinking the interview with Detective Morgan, he indicated, or his choices. Had he gone to trial, the argument would have been whether or not he should be acquitted of this because of self-defense, or whether or not he should be found guilty, or whether or not he should be found guilty of the offense of voluntary manslaughter. August Peters' state of mind would have been everything with regard to self-defense, because the question would have been, and I'm just going to summarize, assuming we got a self-defense instruction before the court, was it reasonable in the mind of August Peters to assume that he needed to use deadly force to protect himself from substantial bodily harm and or death, or conceivably another? That would have been the standard. And based on the things that we've seen, it makes sense how this happened. And it makes sense that August Peters would have thought that use of force or deadly force would have been necessary. August Peters is a little unique in that he, based on the testimony of his mother, had recently been the victim of a violent assault where he was grabbed by the hair and his head bashed against a pole. He lost a tooth and then again bashed against a cement wall. So those are the sort of things that would have been going on in August's mind, would have been unique to August, apart from what happened specifically on May 9th. I believe a jury would have been in their right to conclude that he did have a right to use deadly force in this incident. And I suppose there was always the issue, if they rejected that they would have found voluntary manslaughter, which of course is taking a life after you have suffered some sort of infliction of pain, and that there has not been a cooling off period. I think it's important to clarify the facts. Nothing in the law suggests that a momentary lapse in violence precludes a person from using self-defense. And certainly anybody who's grappled or watched people grapple realize that a counter punch is a defensive mechanism of protecting oneself. It's launched during a lull in the action. It's different than a first strike. It's a response to somebody being hit. August Peters has been hit. He's got to make a decision as to whether or not he thinks that he may end up suffering severe bodily harm or death based on the what had happened to him. It was completely reasonable to assert that somehow a lull in the action precludes him from doing that. Just ignores the logic of any kind of dust-up between two people. Somebody chases your child home, you come out on the front porch and into your yard, and the aggressor strikes you, and you don't have an ability to respond to that because they struck you, and for the moment they're not striking you. Whether or not August was advancing, I think, has been dispelled by the reports of Mathew Nodell in the Washoe Crime Lab. Mathew Nodell reconstructed the crime scene, shot the gun, studied the disbursement of the casings and concluded that there was nothing to support Matt Morgan's assertion that August Peters was advancing on him. As I've argued before, in support of some motions, I think that there was a rush to judgment. The complaint, the arrest is made the very day this happens. Matt Morgan has interviewed Mr. Peters at that time. He appeared to be very dismissive of what Mr. Peters might have been explaining to him, and the complaint is filed 2 days later. It puts you in a difficult situation because once an open murder charge is filed, there's a tremendous risk of what might go wrong, and then there's also the issue of what is the state going to do in a case like this where they charged open murder and the facts support or fail to support that. I think it's undisputed that August was on the grass when he did this. Witnesses, I think Heather Harris, I think the Simmons, all supported that he was on the grass. The speed at which this happened, I think it's clear that the shots were fired bam, bam, bam in a row. Ms. Seward was called as a witness. What is, I guess, the relevancy is just how quick this must have transpired. If she hears an argument and looks out of her window and perceives that Brian Christie is the shooter and August ends up with the gun. I think that her rendition supports what Heather Harris has said and everybody else. So this happened lickety-split. August did not have that much time to think between the time the blows were delivered and the time that he pulled the trigger. I get what is being said in the discussion with Mr. John Peters, August's father. And clearly August is attempting, after talking to his lawyers, to placate his father and justify to his father why his decision is what it is. Certainly if the gentleman had him by the neck and August pulled the trigger, that would certainly put us in a better position as well as August. I suppose if his hand was on the gun, that would be better. But the fact that he may have had a moment to where he was standing still, or even if he took a step back, this happened lickety-split. And the question in the end is what was reasonable for August to believe at that time. Again, I don't know how he pulls the trigger while he's being bludgeoned. He's going to have to do it in an interlude while his aggressor is standing down. You know, the legislature enacts our criminal code, and they give this court the range of sentence it can impose. In a Category A felony, the legislature, or the people through their legislature, have kind of passed laws that lock the court into a specific sentence. Category A felonies are a minimum term and a maximum term of life in prison, and probation, as far as I know, is not permitted. With regard to a voluntary manslaughter, which this is, the penalty is 1 to 10. The legislature has given the court some discretion, and the court can grant probation. The court could give him 1 to 4 years. The court could go as high as 4 to 10 under the notion that under our sentencing laws, the minimum can't be more than 40% of the max. So this court could give probation. It could give as low as 1 to 4. It could give as high as 4 to 10. And then at that point, it's really up to the Department of Prisons and or probation. Taking a life is a necessity in a voluntary manslaughter prosecution or conviction. So that is not unique in the sense that, well, it does not necessitate a prison term, because a taking of a life is going to exist in every voluntary manslaughter, even ones where a court is inclined to give probation. The legislature obviously believed there were situations where, in spite of loss of a life, probation is appropriate. August is a young man, hadn't even completed high school, was 21 years old when this occurred. He has, as the PSI reports, no prior record. He is a bigger man today than he was then. But he's still not going to weather prison the same as somebody who has been through the system, has been to prison, physically a bigger person. So the penalty this court imposes on August, I would say, if it's going to prison, he is going to suffer in a different sort of way than somebody who is older, callous, and has been there before. Relative to others, I believe he's entitled to a lesser sentence than what would or could have occurred in another situation with an older person, with somebody with a longer criminal history, or somebody that didn't commit the offense under these circumstances, where until he pulled the trigger, he was 100% blameless to how this scenario came down. In terms of redemption, I think August is absolutely redeemable. He didn't run. He put away the gun. He called the police. He acknowledged and faced the consequences. There's a proverb about a guilty man runneth when no one pursued, and a righteous are as bold as a lion. And I think Brian Christie is the one who ran. I think once the offense occurred, the righteous was August Peters. He took responsibility, put the gun away, called dispatch. The dispatch tape, and I think the interview with Matt Morgan, shows a person who absolutely was scared to death, absolutely regretted what they did, felt bad for themselves, felt bad for the consequences of their actions. The character letters from August's mother, brother, father, and sister-in-law, they show he's a good person, has a loving and supportive family. He's a likable guy. He's been a good inmate since he's been incarcerated. I never seen before where somebody facing homicide charges ends up as an inmate worker, but he's been an inmate worker, and he's been in custody over 600 days with no write-ups whatsoever. I think the PSI and the sentencing memorandum which we generated, which in its entirety wasn't really spoken to today, shows that August hasn't always had the opportunity to walk on the sunny side of life. There's been a broken home. There's been some issues with drug addiction in the family. I think that the evidence shows that he can be productive, responsible, he can adhere to social norms, he can contribute to this world. I think all of us, including August, are a lot more than the worst things that we find ourselves doing in life. I ask the court to grant Mr. Peters probation.
Thank you, counsel. Mr. Pasquale, argument?
Thank you. Judge, I think this morning and today what we've been witnessing is the defense's case had this matter gone to trial. Establishing facts before a jury. I think that's what we've been trying to hear here. And really, though, at the end of the day, that's not what matters. That's not what counts. What counts are the facts as they were pled to, the facts contained in the amended information. Those are the facts that matter. Now, so when we hear the different defenses that have come up, That he didn't do it, someone else did. He did it, but it was self-defense. He didn't do it, the cops rushed to judgment. Well, it's all the victim's fault anyway. When we hear those facts, they don't matter. What matters is what he pled to, the facts contained in the amended information. Now, regardless of how inconsistent those separate defenses that are being raised now here for the first time, regardless of how inconsistent they were, he did plead. We're here for sentencing. It seems that maybe the considerable amount of evidence that we've listened to didn't really establish anything of any bearing other than potentially the defendant may have been untruthful when he talked to the police. To the extent any of that evidence that we've heard is relevant to sentencing, it's obfuscated and belied to a point by the two exhibits from the state. I think that the only evidence that has any real weight here are the defendant's statements. As much as I said it was self-defense, like deep down, dude, he was almost a yard away from me. I've proven up by Mr. Stermitz's point that he was 5 feet away. He wasn't attacking me, he wasn't advancing, he wasn't. He was standing there. He was a dummy that stood still and I shot him. This is on me. I fucked up. I'm not going to sit here and fucking do this shit anymore. Saying I'm right when deep down I'm not the right fucking right. That's the defendant's statement. That statement isn't somebody else did it. That statement isn't it was self-defense. That statement isn't, well, blame the victim or the cops rushed to judgment. That's the defendant telling you he shot that dummy. Judge, I think all things said and done, I think given the facts, 48 to 120 in the Nevada State Prison is the appropriate amount of time. I think probation should be denied. The statute also provides for a $10,000 fine. I think that would be appropriate as well. Thank you, Your Honor.
Ms. Gould, does the Division of Criminal Probation have anything further to add?
No, Your Honor.
Thank you. And Mr. Peters, will you please stand? Before I impose sentence on you, you have the right of allocution, which means that you may make a statement to the court or present information and mitigation of punishment. At this time, do you wish to make a statement?
Yes, sir.
You may.
First and foremost, I would like to apologize to Doug Hickenbotham's family and friends for what had occurred on May 9th, 2020. I will also forever live with that decision of my actions. If I'm forever deeply sorry, and I understand sorry cannot bring Doug back, and I'll forever live with that. And if I could change things, I would. I would take it all back and do it differently in that regard. Your Honor, it's almost 2 years that I've been in jail. I'm in a GED program to get my, at least a GED of some sort. I am striving in counseling. I'm wanting to succeed in life. I want to continue in life as a productive adult, productive citizen. I know I can do that. And I just please ask of you, sir, to give me one opportunity. Just one chance and I know I can make good with it. That's all.
Thank you. Appreciate your statement. And Mr. Pasquale, do we have any victim impact statements today?
Your Honor, the victim has logged in. She had informed us that she did not want to speak, but I would ask that the court inquire of her whether she's changed her mind.
Thank you, counsel. The precinct's investigation report does have an attached handwritten, or I'm sorry, not hand, typed statement by Ms. Leanne Dennis. Ms. Dennis, I believe you are on the Zoom with us today, and it wasn't clear to me if you intended to make a victim impact statement on the record today. Ms. Dennis, are you there? Okay, hearing no response, the court does have the one-page typed statement of Ms. Dennis, and that has been reviewed by the court. And to the best of your knowledge, Mr. Pasquale, any other victim impact statement?
No, Your Honor.
Okay. Very good. Mr. Peters, can you please stand? Hearing no legal reason why you should not be sentenced and based upon your plea of no contest, this court does now pronounce you guilty of the crime of voluntary manslaughter, category B felony. In accordance with the laws of the state of Nevada, it will be the order and judgment of this court that the defendant, August Anton Peters, be sentenced as follows. As a part of the sentence in this case, the court renders judgment against you in the amount of $25 as an administrative assessment, $3 DNA administrative assessment, $150 DNA fee. And the court further sentences the defendant to a minimum term of 48 months in the Nevada Department of Corrections and a maximum term of 120 months in the Nevada Department of Corrections with credit for time served in the amount of 684 days. The court will order that Mr. Peters be remanded to the custody of the sheriff to carry out this sentence. That'll be the order of the court today, and we will be in recess.
Recording stopped.